My name is Haney Johnston, and I'm the attorney at the Haney Law Firm. The Haney Law Firm has been a participating law firm with Texas Legal for almost a decade now. We are located in Austin, Texas, and were founded by my mother, Susan Haney, who is the lead attorney for many years. My sister, Amber Haney, is our senior paralegal, and she is often one of the first contacts for potential clients with our firm. Now, we provide estate planning and probate services to Texas Legal members, and we really focus on trying to make sure that the process is as easy and seamless as it can be. Because we know that getting your estate planning done is kind of like going to the dentist. Nobody wants to do it, but everybody should. Today, we're going to be talking about estate planning and the different benefits that are available under your Texas Legal plan. Texas Legal is a statewide, nonprofit legal benefit plan that was founded by the State Bar of Texas to better meet the legal needs of Texans. They provide members access to over 400 network attorneys, and Texas Legal offers various insurance plan options. With Texas Legal, members are able to create or update their estate plan once per plan year with a participating attorney. Contact information for Texas Legal will be in the comments and description box of this webinar. Please contact Texas Legal for more information on plan benefits. So today I want to talk to you a little bit about the basic documents that we at the Haney Law Firm provide to Texas Legal members as part of our basic estate planning package. So the first document is a will. Now, this is the one that gets all the attention, but it's actually just one of the 6 documents that we recommend. The will is going to be the document that disposes of assets after your death that don't have a different designated beneficiary. But beyond that, wills also appoint someone who will take care of your affairs. So they will appoint an executor. Now, it's the executor's job to collect assets, pay debts, and then make the distributions to whichever beneficiaries that you decide. Beneficiaries can be people, they can be charities, can be different types of organizations. Whatever's important to you can be included in the will with some limits. Now, a lot of people have young kids, and for young kids, there are special considerations that the will needs to address. The first is a trustee. So under the laws in Texas, minor beneficiaries generally cannot inherit directly through a will. Instead, there needs to be some sort of vehicle for holding those assets on behalf of that young child. We generally recommend a testamentary trust in order to accomplish that. What this does is it will hold these assets for the child until they reach a certain age. We generally recommend at least that the child at least attain the age of 25 prior to receiving the money outright, just because 18-year-olds aren't really known for their financial maturity. Now, in addition to safeguarding those assets, they're also going to decide when distributions are appropriate. So a basic standard that most people use are that the money can be used for the child's health, education, maintenance, and support. So when you're thinking about doing an estate plan for minor kids, be thinking about who you would trust to make those types of money decisions for your kids. Who do you trust to invest assets in a responsible way? Who shares your monetary values about what types of expenditures are important and what types of things aren't as important for your family? The other big consideration that parents of young kids need to consider is who they want to have physical custody of their kid if something happens to both of the parents prior to the child reaching the age of 18. This person is considered the guardian. So this is going to be someone who's going to be in charge of making decisions about where your child lives, where they go to school, what type of medical treatment they're going to receive. So it's really important that you pick someone who shares your values. And those are really some of the big considerations about that most people need to consider when they're starting to draft a will. We're happy to help you weigh pros and cons of certain people and help you decide who's the best fit for each role. But ultimately, that decision is going to come down to you and what you are most comfortable with. Now, The second document that we typically provide Texas legal members is the medical power of attorney. Now, this is one of the documents that gets overlooked a lot. It's not as exciting as a will, but it's just as important, if not more important. The medical power of attorney is going to be the person who makes medical decisions for you if you can't make medical decisions on your own. So this can be a temporary incapacity, like you're in the middle of a surgery or you've just been in a car wreck, or it can be a more permanent incapacity, like a stroke or some sort of cognitive decline. This document is generally going to be automatic upon that disability, so it's not going to be something that needs to go through the courts or anything like that. A doctor will make the call about whether or not you can make your own medical decisions. Now, some of our clients have concerns about specific restrictions that they want to be placed on what type of medical care they receive. Perhaps they have religious restrictions on things like blood transfusions or other types of dietary restrictions. Those are the types of restrictions that can be placed in this document. But just placing those restrictions in the document is not going to be a substitution for having an open and honest conversation with your medical power of attorney about different types of decisions that may need to be made. We generally recommend that you have at least a primary and a contingent medical power of attorney, but you can have as many backups as you want. One thing that people don't often consider when choosing a medical power of attorney is that person's accessibility. So you want to pick someone who you can get a hold of on the phone. So some common concerns that people have are if they have a loved one who's in the armed forces and may be deployed and is not easily accessible, or someone who has the type of job that keeps them away for long periods of time in places without much cell phone service. The next document I want to talk about goes hand in hand with the medical power of attorney, and that's the HIPAA release. So what the HIPAA release generally does is it provides access to medical information to the people that you list in that document. This is important for a couple of reasons. One, if someone needs to handle an insurance dispute on your behalf or apply for different types of disability benefits, they're going to need access to your medical records in order to do that. Another scenario may be if they have concerns about your care and they want to make sure that they understand exactly which medications you're receiving and exactly how often doctors and nurses are visiting you, and making sure that they fully understand whatever your current medical condition is. Now, this is really important for your healthcare advocate who may or may not be the same person as your medical power of attorney. Some of us have several family members who would be involved in our care. Now, when it comes to medical power of attorney, we generally recommend that that's just one person acting at a time, whereas the HIPAA can be multiple people. So if you're in the hospital, who do you want to be able to call and get checkups about you? Who do you want to have the ability to be apprised of whatever your current situation currently is? Another interesting thing about the HIPAA release is that it's one of the only documents that's also effective after your death. So generally speaking, a HIPAA is going to be good for up to 2 years after your death, unless you place other restrictions within the document. This is important if someone has concerns about a possible medical malpractice claim, or if they have concerns about the care that you received. This document can allow them to skip a couple steps and get direct access to that medical information without having to go through a lawsuit or a subpoena. The last medical document I wanted to discuss is the physician's directive, which is commonly referred to as a living will. So what this document is a basic guideline for your medical power of attorney and your physician about what quality of life means to you. Now, this is not the same thing as a DNR or a do not resuscitate order. That document is generally only appropriate at the very end of your life when you're entering hospice care. This document's a little bit different. This document talks about what you would want in certain scenarios to happen. Would you want to be kept alive with ventilators and other machines? Would you want to be kept alive if you're in a persistent vegetative state by feeding tube? None of these conversations are very easy to have, but unfortunately, they're very important. Now, another thing that we always tell our clients is that while a physician's directive is very important, it is not a substitution for having an open and honest conversation about what quality of life means to you. Realistically speaking, there are hundreds, if not thousands, of scenarios that can affect whether or not you would want to be kept alive in different situations. And a 3-page document is just not going to get anywhere close to addressing all of those situations. But if you have these open and honest conversations with your loved ones, then it can be easier for them to step into your shoes and make the decisions if they unfortunately have to. The next document I want to talk about is a statutory durable power of attorney. Now, this is commonly referred to as a financial power of attorney. This is one of my favorite documents because it has so much flexibility and can be used in so many different types of situations. Broadly speaking, for a basic financial power of attorney, you're appointing one person who will make financial decisions on your behalf. Now, financial decisions is really broad. It can be real estate transactions, investment decisions, applying for different types of benefits, having access to digital assets, all of those types of things. There's a long list of powers that you can either give to that power of attorney or you can withhold. Additionally, you can also give your power of attorney a special gifting power that would allow them to divest you of your assets if we needed to get you qualified for public assistance programs. Now, just with like the other documents, you can also place restrictions on your power of attorney's ability to make decisions. So, for example, you may not want them to have the right to change beneficiary designations on bank accounts or life insurance policies. The other cool thing about a power of attorney is that the financial power of attorney is that you can make it effective either immediately. So as soon as you sign it, this person could sign your name on different transactions or do things on your behalf, or only upon later incapacity. Now, again, like the medical power of attorney, this is not a court determination of incapacity. This is going to be a physician's determination of incapacity to handle your financial affairs. Now, these powers of attorney can be very broad, that include basically everything that may need to be done, or you can make them very specific for a particular situation. So, for example, let's say that you are going to be traveling for work and you're going to be gone for several weeks, but your house is currently on the market and you want to allow your spouse or another trusted family member or a friend to close on a real estate transaction. So we can make that power of attorney limited for just 60 days or 6 months, and we can limit it to financial transactions regarding just that piece of property or real estate broadly. There's really just a ton of flexibility so that we can make it something that you're totally comfortable with. Along those same lines, we can also have various co-agents. So it doesn't have to be just one person. So if you have multiple adult children that you want to give access to your financial accounts, then we can do that as well. We can make them be able to make decisions individually, or we can say that a majority of them have to agree, or we can even write it so that those decisions have to be unanimous. Now, the last document I want to talk about, quite frankly, if you have a comprehensive estate plan, this document most likely is never going to matter. But with the rise of news coverage around guardianships and conservatorships, more people have questions about the designation of guardian in advance of need. So what this document does is tells the court who you would want to serve as the guardian of your person and the guardian of your estate. In the highly unlikely scenario that 1, a court finds you to be totally and permanently incapacitated, and 2, some situation arises where your powers of attorney are going to be insufficient to deal with whatever scenario has presented itself. So that's why I say for the vast majority of people, this is never going to matter. But people like knowing that if it the situation were to arise, they have the ability to tell the court who they would want to serve as their guardian so that an agency or disinterested third party doesn't suddenly become in charge of your life, where you're going to live, what type of medical care you're going to receive, and things like that. So again, just like the other documents, we encourage our clients to have multiple people listed. The other thing that we can do in the designation of guardian is specifically disqualify a person to serve as your guardian. So if you have a very contentious relationship with a sibling or with a child, we can put in that document that this is who we want, but this is definitely who we don't want to serve as our guardian. So those are the 6 basic documents that we generally recommend that Texas legal members get if they're going to get a basic estate planning package. Now, your situation may be different. There may be other documents that we want to add on, like a transfer on death deed or a disposition of remains. But as a minimum, we always recommend these 6 documents. We often get asked if there are special considerations for people who are part of a blended family. So a blended family is generally going to mean a family where either one or both of the spouses have children from a prior relationship, and they may or may not have children of this relationship as well. And there are a lot of different considerations for people who are either children of people in a second marriage or a second relationship, or the people who might find themselves as second spouses or being part of this new relationship. The first thing that I always like people to think about is what would happen to the family home. So for a lot of people, the home is the main asset of the estate, and they want to make sure that they have something preserved for their children in the event that something were to happen to them first. But at the same time, they want to make sure that their house remains a place where their spouse can continue to live, either for a certain period of time or for the rest of their life. So when we're thinking about this situation of the family homestead, some things to keep in mind are if the spouse is going to be responsible for all of the expenses or just part of the expenses, if we're going to give them just a life estate in the home and preserve what's called the remainder interest for these other children. We may take into consideration things like who can live in the home at a specific time. So if we have adult children who are still living in the home or minor children, how are we going to handle that? So those can be really tough conversations to have, but they're extremely important. Because what happens if you don't plan is that the default rules come into place. And generally, default rules serve an important purpose, but they're very difficult in reality to make work. So under the default rules, if something were to happen and there are children from a previous relationship, what's generally going to happen is that there's going to be multiple owners of this home in some way. And if there aren't clear rules or expectations that have been set, then it almost always is going to lead to conflict. Now, another thing to keep in mind when doing estate planning for blended families is what's going to happen if you're in the hospital. Who do you want to have access to information? Now, this is really important, especially when the relationship between the new parent and the previous children maybe isn't so great. So unfortunately, that's a common reality nowadays. And so thinking about, okay, if I'm going to have my spouse making medical decisions, do I still want my kids to have the right to call and check on me? And that's where these different documents can do different things. So we can have the primary decision maker, but we can make sure that everybody has access to information. We generally do not recommend that you keep funeral instructions in a will. And the reason for that is fairly simple. The funeral decisions need to be made way before we need to worry about probating the will. What we generally recommend is that you make sure that your family knows what you want on a very basic level. So, do you want to be cremated? Do you want to be buried? Is there a specific place where you want your body to be laid to rest? Now, you can also leave written instructions in one of two ways. The first way is an informal document that you may just say a letter to my family or another type of funeral instructions document where you can really get into the nitty-gritty of what you want. So what songs do you want to play? Things like that. Now, if you have concerns about whether or not your family will follow your instructions, perhaps you were raised in one religion that has this very specific burial instruction and you're no longer part of that religion. Or maybe you are still part of that religion and it's extremely important that you are buried within a certain number of hours and in a certain way. We can also provide you with a disposition of remains document. Now, in this document, you appoint an agent who will have control over your remains in the event of your death. In that document, you can also place restrictions on what they can do. So you can direct your agent to have you buried, to have you cremated, to have you placed in a certain cemetery, whatever is most important to you. Now, in terms of paying for that, you have a couple of options. You can do a prepaid funeral. You can have a bank account that's payable on death to that agent with the understanding that they're supposed to use that money to pay for your funeral expenses. Or you can also just wait until the will's been probated and whoever pays for your funeral can ask for reimbursement from the estate. Choosing an executor is a really important part of developing a good will. When considering an executor, keep in mind some basic logistical information. This person is going to be in charge of dealing with all of your assets. So that means the big stuff like bank accounts and cars. That also means the little stuff like your socks and your clothes. So make sure that it's somebody who's not going to be overwhelmed by having to deal with all of that all those different things that need to be dealt with. If there's someone who lives far away and they need to clean out your home or your apartment, this may mean that they have to travel down in order to do that. So think about whether or not that might create a hardship for them. Now, you do have the option of providing them with compensation in order to make the job a little bit easier for them. As a general rule, executors are going to be reimbursed for any expenses that they incur in dealing with your estate, but on top of that, you can also provide for compensation. Some people like to give a flat amount, based on the size of their estate and how much stuff that they think that their executor is going to have to do. So that could be a couple $1,000s, that could be $10,000 or $20,000. It really just depends on your individual situation. The other thing that you can do is provide it as a percentage of the estate. So you could say that 5% of your net estate or 10% of your net estate will go to your executor. Now, for me, I tend to prefer flat fees as opposed to percentages, but every situation is a little bit different and sometimes a percentage makes the most sense. Another option that you can consider if there's not a person that you trust to do this is to actually hire a corporate or professional trustee who normally will either charge by the hour or on a percentage basis. If you have a 401k that you started prior to marriage and that has a beneficiary that is not your spouse listed, the question of whether or not that money would actually make it to your designated beneficiary is kind of complicated. And quite frankly, like lawyers say all the time, it depends. One of the first things to keep in mind is that generally these designated beneficiary designations do override whatever's in your will. However, there are certain assets where that becomes a little bit more complicated, and a 401k is one of those assets. Generally speaking, the spouse has the right to the 401k contributions that are made during the marriage. However, they can waive that right, but they have to do so in writing. Another thing to keep in mind is that if community property does get placed into that 401k, your surviving spouse might try and make a claim for a community property contribution that should be reimbursed to them. But it just depends. So unfortunately, the answer is complicated. People always want to know when they should update their will. We generally recommend that you look at your will at least every other year and just see who you have serving in different roles. Because over time, people are going to age out or they may move across the country. relationships change. So it's really important that you're looking at it every couple of years just to remind yourself of who you have in certain roles. Beyond that, anytime you have a big life change, so you have another kid, there's a death in the family, you acquire substantially more assets, anything like that, those are all great reasons to update your will. The last reason why you might want to update your will is just because it's been a while since you've done it last, and laws change over time. So if you got your will done 20 years ago, those laws were vastly different than they are today. And as Texas legal members, you have the ability to update your will at least once per plan year. So there's really no reason not to. If you and your spouse are thinking about starting a family and want to create an estate plan that takes that into consideration, there are some things that we can do. The first is that we can go ahead and create what's called a contingency trust, which is a type of testamentary trust that only comes into play if there are people who inherit from you who are under a certain age. So we can go ahead and appoint who's going to manage money on behalf of your minor potential children. Another thing that we can do is we can provide gifts to afterborn children in your will. So we can define children as being any children who are later born to or legally adopted by you. You should not include ambiguous instructions in your estate plan. A lot of people have a very difficult time making decisions about what they would want to happen after their death. And instead of addressing that head on, they try and kick the can down the road and ultimately try and leave it in the discretion of the executor. But that is a recipe for disaster. So some common things that people want to try and include in an estate plan may be that if their child is married, they want a gift to their child's spouse of a size equal to the amount of love that they share. That's not anything that anyone can actually enforce or follow. So you're going to have more specific instructions. I know that's really uncomfortable because you want to try and provide for all scenarios. But the good news is that as a Texas legal members, you can update your will once a year to reflect those different life situations as they change. So you don't have to have as many ambiguous or if-then types of situations in your will. You should have a separate will from your spouse. We generally do not do joint wills in Texas. Now, you and your spouse's wills can mirror each other, so they can essentially say the same thing, but you do need to each have your own separate documents. So your husband is interested in investing in cryptocurrency or stocks, and they want to know whether or not it can be passed down to multiple people and how that would be handled. Unfortunately, again, the answer just depends. Sometimes stocks have certain restrictions on them. If they were part of a package when you joined a company, the stock options may or may not have vested, and that's other types of considerations that may need to be taken into consideration. Same thing with cryptocurrency. Whichever digital wallet or other type of system that you're using may have different restrictions on what happens to those assets after your death. And so it's really important that you read all of those contracts very carefully, because just like ownership in a business or any other type of asset where there are restrictions on ownership, there could also be restrictions on ownership after death. Thank you so much for joining us today as we talked about estate planning and your Texas legal benefit. My contact information is going to be in the comment box, and so please feel free to reach out to me if you have any questions or if you want to get your estate planning started with the Haney Law Firm.